Okay, great. I'm Jess Stahl. I'm a vice president for data science and analytics, and I work with national data sets. And I'm also a member of the Open Mind team, the UN Privacy Preserving Techniques Task Team, and the UN Pet Lab. I want to extend a warm welcome to everyone joining us today for the UN Pet Lab Open House. So as a little bit of background, the Pet Lab was launched in January 2022 to bring together a community of practitioners in the field of pets to experiment, learn, share their insights with a focus on use cases for official statistics. Members of the UN Pet Lab meet weekly to work through the challenges of implementing pets in concrete use cases and projects that are relevant for the community of official statistics. And so I would like to start by introducing my colleague Maciej Sjog, chair of the UN Privacy Preserving Techniques Task Team, to share an update on the latest work happening within the UN Pet Lab.
Thank you, Jess, and hello to everyone. I will just start with a very short update. Besides UN Pet Lab, which is doing open houses like this one, we also have a regular task team, which is currently finalizing the new guidance on use of pets in official statistics. So that publication will have a lot of case studies, so quite practical examples of use of pets in all over the world, spanning from some production cases to proof of the concepts and pilots, but also update on the techniques themselves. So, for example, we added synthetic data and federated learning techniques, as well as very structured analysis of standards that are applicable when we use pets, and also some findings from legal perspective, which is particularly interesting, of course, for our discussion today. Besides the regular team, we have the legal task team, which is working on the more detailed document, but Mayank will explain that in more detail. These are the main activities at the moment, and we look to publish the new documents and also work with you in the UN Pet Lab. Back to you. Yeah.
Thank you so much. In this open house, our focus will be on the legal aspects of.
Sorry, Jess. Just to add on a little bit, because of we also have the UN. So I'm Ronald Jensen. I'm with the UN Statistics Division. I'm also supporting the various work streams under the UN Committee of Experts on Big Data, Data Science, specifically also supporting the work of the task team of pets, as Maciej was just explaining. Within that, we also have the UN Pet Lab, and I just wanted to add a few words to that. So that's more like the community of practice, where we try to work out practical use cases. So one use case which we have been working on with some of the national statistical offices is on the sharing of trade data. And that's a use case that was already shown a couple of months ago, but it's currently in the next phase. They were deepening a little bit the kind of information that could be shared. Specifically, I think it's Stats Netherlands with Statistics Canada who are taking this on. And other than that, the Pet Lab is having a lot of discussions about this role of statistical offices in data sharing across government. I think that's one of the other issues that we're currently very much talking about. Just more comparing notes, and then this one particular project. And back to you, Jess, on that.
Thank you for that additional context about UN Pet Lab. In this open house, our focus is going to be on the legal aspects of sharing data and use of pets. And our first speaker is Mayank Varia, chair of the legal subtask group of the UN Privacy Preserving Techniques Task Team, who will present on legal and policy considerations when adopting pets when sharing data. And then to give you a preview of what will happen after that in the meeting agenda, then Maciej will share experiences from Statistics Netherlands And then Stephanie Strauss, a policy fellow in the Massive Data Institute at the McCourt School of Public Policy at Georgetown University, will share insights from the U.S. Department of Education pilot. And after the speakers have all presented, we'll host questions and answers. So feel free to put your questions in the chat or note them to yourself so that we can return to those during the Q&A. And then after that, my colleague Ronald Jansen, Assistant Director of UN Stats Division, will facilitate an open house session. So now I would like to invite Mayank to please introduce himself and share his insights about legal and policy considerations in adopting pets.
Okay, thank you very much for the great introduction. Just to double check, can you all see my slides?
Yes.
Yep.
Okay. So good morning. Well, at least good morning where I am. Perhaps good afternoon for you. It's my pleasure to be here. My name is Mayank Varia. I'm an associate professor of computing and data sciences at Boston University. My research background is in cryptography. So in particular, that means I'm not a lawyer and this is not official legal advice. With that caveat out of the way, I would like to describe the ongoing work that our legal task team on privacy enhancing techniques have been up to. So this is a team that we purposely assembled a very broad and diverse group of people. Here's a list of everybody on the team who's participated in at least one meeting of our group. We've purposely recruited a team that spans several areas of expertise, from people who do research into privacy enhancing techniques, National Statistical Organization members, and data privacy lawyers, and additionally recruited for breadth across nationalities and legal jurisdictions represented. The work that I'm going to describe, though, I want to emphasize that everything I say today is the result of a collaborative discussion among our group. It does not necessarily match the views of any particular person or any particular organization listed on this slide. So with that important disclaimers away, let me begin. I have just a one-slide overview of the overall broader task team of the UN Committee of Experts on Big Data for privacy enhancing techniques, which Matthias and Ronald have already described well. But just to remind you, the goal of this committee of experts sort of has 5 pieces: to analyze the suitability of privacy enhancing approaches for the statistical analysis of the sensitive data, to identify example use cases where such methods may apply, to investigate the required technical and legal capabilities, which may be correlated but may not be, as we'll get into today, and other capabilities to assure privacy preservation while allowing analysis of sensitive data. And finally, to collaborate with the other UN task teams and projects and to disseminate findings and learnings within the broader community. This broader team has already produced one UN handbook, first published in 2018, with an update coming this year, as Matthias just said. The focus of that handbook is on describing a variety of technological methods that enable protecting privacy of data while it is being processed, rather than simply protecting data at rest on a system or in transit between systems using encryption. And broadly speaking, there's 2 categories of data privacy protection techniques they talk about. First is input privacy mechanisms that allow an individual or an organization that has sensitive source data to contribute that towards a statistical analysis in such a way that its information is protected throughout the data lifecycle, or all or part of the data lifecycle. And second are output privacy tools that apply sort of at the other end of the pipeline once a statistical result is produced, to try to mitigate risks of statistical re-identification or other forms of disclosure. Okay, so our specific legal task team has the following relatively ambitious goal of trying to describe how privacy enhancing techniques contribute towards adherence with legal obligations under privacy laws across all UN member states. This is kind of an impossible goal. There's way too many individual privacy laws to cover. So instead, what we try to do is build a taxonomy or a methodology of thinking about how to apply pets that are consistent with the law. So our objectives are both this general methodology and also to document specific examples that showcase how pets can open new affordances under the law. In my talk, I'm going to focus on this general taxonomy, and then in the later talks by Maria and Matthias and Stephanie, you'll see some of the specific examples we have. And our audience for our document is a little bit different than for the existing handbook. Rather than data scientists statisticians at national statistics organizations being the primary audience, instead our audience is more lawyers and policymakers, but also the data scientists as well within these organizations. So to make the discussion a little more concrete, let me have a one-slide example of one of the particular kinds of privacy-enhancing techniques, namely a tool from cryptography called secure multi-party computation. This is an example of an input privacy tool, and it allows individuals, companies, and governments to perform joint data analyses without ever having to share their own data sets. So basically, this is kind of a form of data alchemy. We want to build a box where you can put garbage into the box and yet still have valuable data come out the other side. For the purposes of this talk, for my talk, it doesn't matter how this technology works. That was the topic of the prior two UN PET labs and maybe the focus of some of the talks later today as well. But instead in my talk, I want to explore how the law and policy considerations affect when PETs are viable to use. So looking in more detail at this picture, the individual people who have data are generally free under most privacy laws to do whatever they want with their own data. But the hospitals, educational institutions, and government organizations in this picture are often subject to data privacy or protection laws. These legal restrictions are the end result of a series of intentional choices we have collectively made as societies to balance several competing interests. And introducing a new technology doesn't somehow magically make all of those interests go away. So the goal of our task team is to explore the question, when is the use of pets consistent with the law? I don't want to paint this as like a negative doom and gloom picture of pets, though. In fact, pets can have many benefits towards regulatory compliance and achieving policy objectives. First, pets can be an effective tool that contributes towards adhering to a UN member state's laws, norms, policies, and regulations about data privacy and protection. This is because pets have been designed to provide technological data privacy safeguards throughout part or all of the data lifecycle. So, for example, pets can be a valuable tool to assist organizations in, for example, the European Union to achieve the General Data Protection Regulation or GDPR's objective of data protection by design and by default. Second, the data privacy and anti-disclosure protections offered by pets can empower people to contribute their personal information towards data analysis and empower organizations to participate in analyses because they can reduce data disclosure risks perhaps to a more acceptable level. This can lead to greater representation and data products that better reflect all of society, which in turn can improve social trust in the resulting data products. Third, pets can open new opportunities in scenarios where data processing is desirable, or at least the end product of a data processing would be desirable, but the underlying data is subject to statutory, regulatory, ethical, contractual, or competitive restrictions on data use, processing, or disclosure. And this is because pets allow for reviewing only the targeted derived data products that you want that have recognized social or commercial value while otherwise protecting sensitive data. And you'll see more concrete examples of this in the later talks by Maria, Matias, and Stephanie. These examples will show scenarios where pets are empowering in that they can allow for performing statistical analyses that would be much more difficult, if not impossible, otherwise. Okay, so on to our overall general legal taxonomy. So our view is to determine whether the use of a privacy-enhancing technique supports adherence to the law in a particular scenario. One must verify that all participants have satisfied all of their legal obligations. And to do this, our team recommends following a three-step kind of a mission mapping type of process. So first, enumerate all of the actors involved in any aspect of data processing or technology development. Second, determine the scope under which each actor of the laws under which each actor falls, and determine the types of affirmative requirements or limiting restrictions that these laws impose on each of these actors. And third, analyze the extent to which the deployed pet is consistent with all of these requirements. Additionally, these considerations must be applied throughout the data lifecycle from idea conception to system decommission. And for this reason, it is critical that any statistics-related project must involve appropriate legal and regulatory experts, both when the project starts and also whenever any meaningful changes are made to the system. Because in practice, the legal position depends very much on the individual fact patterns of a specific deployment scenario. So this is our attempt to try to provide a general set of guidelines that a lawyer could use when trying to do this mapping onto an individual scenario. And in the remainder of my talk, I'll go through each of these aspects of our overall legal taxonomy in more detail. The first piece is the actors. So in the context of pets, from a legal perspective, we identify several different types of actors. The taxonomy in our document is inspired most directly by the European Union's GDPR regulation, but we believe that the many other privacy laws have a similar high-level structure. So the first group we consider are lawmakers, regulators, and judges who could make, enforce, and interpret the meaning of data privacy laws. The statutes and guidances can vary by region, and the legal position depends very much on the individual fact patterns of any project, which is why I'll reiterate the importance of consulting qualified legal experts from the start. Second, in our taxonomy, one must identify the legal entities who are intended to either benefit from or be protected by the relevant laws. So for example, these might be the people who meet the legal definition of data subjects under the European Union's GDPR, or as consumers under various privacy laws in the United States, and so forth. These actors have certain legal rights and protections pertaining to their personal data or personal information. Third, we must identify the actors who have obligations under the relevant laws and who are typically subject to legal liability if they were not to comply with these obligations. So for example, a processor of personal data may fall under the jurisdiction of a privacy law. Finally, we must consider the suppliers of the tools of pets themselves. Depending on the facts of a particular scenario, they also might or might not fall under the prior two categories. The key point here is there's a difference between the person who creates a privacy enhancing technique, the people who develop a tool that implement a pet, and the folks who offer a service that make use of a pet. These differences may influence each of these actors' legal obligations and liabilities. In the second step of our taxonomy, we try to analyze a variety of different data privacy and protection regulations. Again, we can't systematically go through every single privacy law that affects a UN member nation or part of it, but we tried our best to synthesize and extrapolate common features that tend to appear in a lot of privacy laws and tend to connect to the question of whether a privacy enhancing technique is compatible with the law. So we believe that an understanding of a regulatory environment can be achieved through consideration of the following four aspects. First, to determine whether an action falls within the scope of applicability of a particular regulatory regime. Some jurisdictions have omnibus general purpose regulations, whereas others might only target a subset of data held or activities performed or actors. Moreover, some laws may be framed in such a way that anybody who does or does not perform a particular action will be legally liable, whereas other laws will set out certain conditions or criteria that must be met by an actor before it even becomes subject to the obligations of the privacy law. Second, one must consider how a regulatory event impacts the actor's use of data. At a high level, we find three types of regulations that are commonly in a variety of different data privacy laws of increasing responsibility. Some data privacy laws limit disclosure of particular derived data products to just other actors. Some might restrict the use of data of a particular specific protected type, and yet others might generally regulate data processing, whether or not it's disclosed to others and whether or not it retains its protectable quality. Third, we must consider the style of regulation in any particular privacy law. Some regulations require an actor to take an affirmative step, like obtaining informed consent. Other regulations might require stating a concrete purpose for each action undertaken. Others might issue blanket prohibitions on certain uses or disclosures of data, and yet others might impose a fiduciary duty of care to consider the interests of other actors throughout the data lifecycle. And these styles will impact which privacy enhancing techniques are or are not compatible with these obligations. And finally, we must consider how pets affect additional data subject rights. For example, depending on different data privacy laws, they might either require or prohibit long-term access to certain data. They might either require it to comply with certain legal obligations or prohibit it to safeguard data subjects' privacy. The key point here is even if pets in general improve data privacy overall, they might also present unique difficulties in meeting other legal obligations, such as ensuring accuracy or fairness of results, or for example, providing individuals with a proactive right to access, modify, or delete their personal data. At this point, you might be asking me the question, just tell me, what is the answer? Is the use of a pet compliant with the law? But unfortunately, this is almost never the right question to ask. Very few laws fashion support possible protection mechanisms and for the law to remain relevant and flexible as technology evolves. So for this reason, in our forthcoming report, we do not provide a one-size-fits-all answer regarding regulatory compliance. Instead, we provide a list of 4 questions that I show on this slide that we believe will guide data privacy lawyers as they assess how a regulatory regime impacts the use of a pet for all actors within a particular use case. Our questions involve determining whether the deployment of a pet is within the scope of a regulation, whether it triggers a regulatory event, whether all obligations on data processing are satisfied, and whether the deployed system is consistent with providing all other required data subject rights. Our forthcoming handbook includes a worksheet that lawyers can use to perform this mapping of the actors to the regulations to the pets. Finally, I want to talk about protecting data throughout the entire life cycle. Data is core to the work of national statistics organizations, and in our report, we identify all the stages within a data life cycle where legal and policy considerations might occur. So starting at the beginning with idea creation, it's best to work with legal experts from this initial stage. When you then move forward to list business requirements, it's important to consider the legal implications of what the system is going to do. At the data planning stage, it's important to consider the scope of what data needs to be collected or obtained and what obligations different jurisdictions might impose on that data. At the data acquisition step, this is the first step in which processing in the legal sense might occur, and the use of pets from this stage onward will influence the regulatory obligations and restrictions imposed. Data preparation often includes multiple types of processing activities that need legal consideration, such as data reformatting, deleting, processing of outliers, or transforming data for bias mitigation. Building and testing a model typically involves either using actual data or using synthetic data that is derived from the actual data. By the system deployment stage, the statistical model is now part of a live system that is receiving live data. This makes clear that data is being processed, but also that the model is being used as part of some sort of organizational function, which may create a circumstance for either explaining a model decision or an affirmative duty of care. Eighth, the model might require revision during the system operation lifetime, and any adjustments may trigger new types of data products created, new types of affected actors, or new legal regimes implicated. At the data decommissioning step, the data is processed perhaps for the final time to do things like secure deletion or archival or repurposing. Data privacy laws may come into play here too, for example, to ensure that any archived models limit re-identification risks. And the final step of system decommissioning must be done in a manner that is compatible with data subjects' additional rights. In conclusion, let me just sort of finish by listing 5 key takeaways from our reporting. First, involving lawyers early and often in a project is strongly advised. Second, pets are typically not black and white mandated by legislation, but they might be either recommended or might be a useful tool towards adhering to a particular regulation in a particular use case. Third, the technological guarantees of safeguard of pets are helpful, but they're not always a silver bullet that ensures consistency with existing laws, policies, and cultural norms. One must think about this further. But there's also an opportunity here that pets can open up new affordances and new kinds of example deployments that may be possible within the social structure that might not be possible otherwise. Fourth, any activity involving data from more than one jurisdiction will necessarily be a lot more complicated because, among other things, you'll have to consider all the steps in our taxonomy across all of the different jurisdictions. And fifth, there's no one-size-fits-all answer here. In particular, different jurisdictions may take different views on the adequacy of a particular pet for a specific given use case. So that's all I have to say. Thank you very much.
Thank you, Mayank, for sharing a very realistic and informative perspective on legal considerations, including and also complementary to the use of pets. And I'm sure many are now especially looking forward to that report. So now I would like to welcome my colleague Matches to share insights from Statistics Netherlands.
Thank you, Jess. Yeah, a lot of these findings that Mayank just explained, I think will be visible now with the practical use cases. So that's the purpose of this part of the session. But first, I would like to introduce my colleague, Maria Ojoyelun, who is legal advisor at Statistics Netherlands. So she will do the most part of the presentation, but I will do some introduction at the beginning. Next slide. So the use case that we have, the project is related to the concept of value-based care, which means delivery of the right medical care in the right place. As probably in some other countries, we see in Netherlands a lot of innovation. So, for example, e-health solutions that aim to kind of improve the care and provide some sort of advice to patients how to behave, what to use during their recovery period. Of course, there is a question how effective these e-health solutions are. And to determine how effective these solutions are, we need data. However, the data that would help to determine this effectiveness is held by very very different parties. So, for example, by hospitals, by medical insurance companies, by GPs. But what is also important is socioeconomic data that is usually held by NSOs, in our case, Statistics Netherlands. So idea here was to partner to make use of our data from Statistics Netherlands for the public good in that case, and to do this in a privacy enhancing way. The case is, how to say, from the calculation perspective, is relatively simple. It is what they call a private set intersection with analytics. So you have data sets at 3 input parties. One being hospital, second one being medical insurance company, and the third one being Statistics Netherlands. And with these 3 parties, different regulation applies, but Maria will explain this in a minute. And the purpose of the PET solution was to perform the computation that is needed to get insight into the effectiveness of e-health solution without disclosing any of these parties' sensitive data to the other party. So kind of it is completely zero trust model in that case. And we used a certain secure multi-party computation techniques such as homomorphic encryption and secret sharing in that use case. But what was also interesting here, we also used smart contracts based on the blockchain type of technology to also provide some verification for the types of queries that are allowed to be performed in this environment. So that was the use case. The interesting part of this use case is that it could be interesting also for other NSOs or other organizations, because what we see, like with the COVID-19, but also other crises, is increased need to combine medical data with some background socioeconomic data, which is often held by or which is held by national statistical offices. So this use case could be generalized in the future for some other use cases. But with this, I will pass to my colleague Maria to explain the legal perspective of this use case.
Yeah, thank you, Matthias, for the introduction. This use case also was successful also in for legal aspects. So because it's very sensitive data, we can also use it for less sensitive data. So with only MPC and without the blockchain. So and we use it also, like Mayank said, the legal advisors, the lawyers were from the beginning, from the start of the project involved. And That's also needed because we have to understand what happens technically, and the technicians need to know what legal issues there are. So that was a very good cooperation between us. On this slide, we mentioned the moments of processing for legal relevance, and also what Mayank said, these are less steps, but the same steps you mentioned, Mayank, are here involved to know who is responsible, which party, and what do we need to put in the agreement to make sure that everyone knows when he or she, which party is involved with it. And not only the three parties of the medical insurance, the NSO and the hospital, but also the technical party, TNO, is also a process of a controller. So I'll show it in the next slide. Next slide. Yeah. So, of course, pet using is not anonymous. It's a pseudonymized. So we are in the EU. Also, the GDPR is you have to comply to the GDPR. And the smart contracts is not a guarantee for the privacy, so we always have to check afterwards whether there are no privacy issues anymore. And also, what I said, all parties, including the party which have no data but who are technical involved, are the joint controllers. So we have to make the agreement to all parties. And as said, the PET is not the end goal, but it very fits well to the privacy laws like data minimization, and also to use less data only for the purpose which they are processed for. Next slide, please. Yeah, this is also what we used. What kind of acts, what the rules we have to apply to, and besides the GDPR or some other privacy law in the other countries, we also need to involve the Statistical Act, and of course the rules for the hospital and the insurance company. And also the technical party, TNO, has also its own act. So we have to comply to all these legal issues. And that's a framework where we use the PET for. Okay, next slide. The role of the legal advisors in this project is that because it's always that the data should comply with the privacy law, and we have not other countries. This time it was only in Holland, so that's quite much easier than when you are international involved. As I said, the legal advisors need to understand what's technically done, and that's why they should be involved from the start on. The joint controllerships between the decision makers and the joint controllers, and also we had to make the joint data protection impact assessment. So that's very important, because then you know what we are doing, and that's also for the planning, and all the steps before using PET are in kaart gebracht. And of course, besides all, there are still ethical questions because what do you want to investigate, the purpose of your project, and that also needs to be addressed. Thank you.
Yeah, thank you, Maria. Yeah, back to Jess for the next.
Yes, thank you so much for sharing your experience and insights regarding the legal aspects of implementing pets in a realistic use case, including legal framework that can be applied to pets research and the role of legal advisors. So now I would like to invite our colleague Stephanie Strauss to talk about a use case with the U.S. Department of Education.
Thank you, Jess. Can everyone see my slides now?
Yes.
Okay, great. Thank you. Hi, everyone. My name is Stephanie Strauss. I'm a policy fellow at the Massive Data Institute at the McCourt School of Public Policy within Georgetown University. And I'm here to present on a pilot project that my team and I, including my PI, Amy O'Hara, as well as computer scientists from Galois, we collaborated on to complete a secure multi-party computation demonstration project within the United States Department of Education, and to speak on the legal and regulatory issues that we faced. So the specific agency we worked with is the National Center for Education Statistics at the Department of Ed, which is the statistical research wing. And every 4 years, they prepare the National Post-Secondary Student Aid Study listed here, or NPSAS. And NPSAS reports on average federal aid received by undergraduate students in the United States. And the survey is authorized by the laws listed here. To produce these statistics, NPSAS links data with another group at ED. They take their data from confidential surveys of students regarding their attendance at these institutions and income brackets and other institutional and student characteristics, along with sampling weights, and then link that data to another database at ED, specifically the National Student Loan Database System, or NSLDS, which contains all the student loan balances and grant amounts for the United States. So this figure represents the protocol that is currently used in production today at NCES to create the NPSAS report. There's a lot of acronyms beginning with N, so bear with me, but the important thing to remember, NCES is a statistical research wing that forms this survey and creates these reports every few years, and the two parties are NPSAS and NSLDS. So we'll start with NPSAS, let's call it Party A. They send their request file containing their sampled students to NSLDS, or Party B, and NPSAS, in doing so, reveals which students were selected as representatives in their statistical study. This is a nationally representative sample to NSLDS. And in reply, NSLDS, after linking the NPSAS sample to its database, sends back the very sensitive details about each student, specifically their loan amounts, their grant amounts, and some other personal financial data in its results file there. So NPSAS is accountable for assuring the privacy of this data against threats like data breaches or insider compromise, while NSLDS has to fully trust that the NPSAS systems are as secure as its own. In contrast, here we have the privacy preserving approach we used for our pilot using SMC secure multi-party computation. A quick aside, I know Mayank touched on this a little bit, secure multi-party computation, it's a subfield of cryptography that allows for a joint computation of a previously agreed upon calculation, like a statistic, among two parties that cannot or do not want to share their data with one another. So two data holders with extremely sensitive data or information. And so the calculation is performed while this data is encrypted, and then the aggregate results, in this case, the tabulation file, is decrypted. So neither party sees the other party's sensitive data. So in our protocol, what we did was NPSAS and NSLDS, NPSAS selects their students as before, they upload their data to the SMC protocol where it is encrypted. NSLDS also selects their data, the loans and the Pell Grant information for the specific years of interest, upload it to the SMC application. The data is also encrypted. There's a shared computation there. And then the results are decrypted, and these are the aggregate loan and grant amounts and turned into the report that is sent to NCES at the bottom. And here, in actuality, the NIPSAS report actually involves more than just 2 data sources, but for our pilot purposes, we only use these 2. So our demonstration, for all intents and purposes, was successful. We successfully recreated over 100 statistics that matched our truth deck. The truth deck in this case was the same computation, but performed in the clear using statistical software, mimicking the way that it is done currently. And it was efficient in terms of computational time. I ran these experiments in collaboration with Galois. I uploaded the 2 separate data sets, 1 per server, to simulate the 2 data owners using simple command line interface. I'm not a cryptographer, I'm an education data analyst, and I was able to do this fairly easily, and no party learned the other party's input. However, we did face legal barriers as well as regulatory barriers, which I will get to in the next slide. So the first issue we faced was that the council and the attorneys at the Department of Ed were not going to let us conduct this demonstration project at Georgetown, for example. It had to be at Ed, nor were they willing to discuss if our demonstration even constituted a FERPA violation. FERPA is the Seminole Education Data Privacy Act in the United States that governs student education records. They were not even willing to discuss that unless we were under the Ed umbrella. So to resolve that, NCES made me a fellow at NCES so I could access data and be within their trusted computing network and have access to their secure cloud-based servers, etc. The second issue in terms of disclosure, so here I have the definition of a disclosure according to FERPA, which states that a disclosure is any release or transfer of PII contained in any education records and to any party except by the party that created that record. And the Office of General Counsel, the attorneys at Ed, particularly from the federal student aid side, so protecting the loan and grant amount data, they felt that if any data under their control were to leave their control at all, that constituted a disclosure. They did not want me to see the data, even technically as an employee of Ed when I was made a fellow. We had hoped to use the original raw data containing the Social Security numbers, the sensitive financial information from NIPSAS and NSLDS for our project, but unfortunately, due to the distrust, it got watered down, and so we were provided a de-identified restricted use file provided by Ed, which is researchers can apply for access for this. For example, it has hashed unique identifiers that replace the student Social Security numbers. And the lawyers also did not want the NIPSAS team to see the data. Remember, right now in the current protocol, NIPSAS doesn't get to see NSLDS's raw data. NSLDS links what NIPSAS has sent them and then returns back that results file. So that was the sort of most primary barrier we faced, that we didn't even get to dig into the MPC FERPA issue as much as we would have liked with the attorneys at Ed. And didn't achieve full clarification on whether or not encrypted data they were considering, that being a disclosure under FERPA. If we had the chance, we would have explained to them that I would not have seen anything. I was not, if we actually, in our ideal scenario, I would have guided NIPSAS and NSLDS, the 2 data parties, to upload their raw data, the micro data to the system, the non-de-identified data to the MPC system where it would have been encrypted. So the data does not leave the original servers, so to speak, but we were facing the lawyers from Ed balking at the top issue above, as I mentioned. So there were also a couple regulatory barriers. This did not play out in actuality, but this is more forward-looking. If Ed were to implement, and actually integrate secure multi-party, let's say, as a routine way to conduct the NIPSAS survey, we would face a couple regulatory hurdles. So the Privacy Act of 1974 has a couple stipulations for United States systems of records, and the system of records is any group of records under control of any agency through which information is retrieved by PII. And any change that you make to that system of records triggers a system of records notice. So the agency has to publish that notice in the Federal Register. It has to be posted for 90 days for a comment period. It is bureaucratically and administratively arduous. And so we had senior executives who were both career and political at Ed who felt that implementing MPC would trigger a system of records notice. However, we argue, changes to IT infrastructure in the past, like switching to cloud computing platforms, has not required or triggered a SORN notice, and we view MPC, similar to the previous presentation, as a means to an end to calculate, something that has been done every 4 years. We are not changing the data; we are just changing how these statistics are being calculated. Another potential roadblock is those same officials felt that we would have to get secure multi-party characterized as a routine use. And routine use is an agency approved circumstance in which a record can be shared outside of that agency. So we argue that it's not the routine use itself is the program evaluation, for example, evaluating the Higher Education Act, which allows for the federal student aid program. But their interpretation was that the PET or PPT itself is a routine use. So that is another conversation that would continually need to be had with these officials. We would need to update the privacy impact assessment, or PIA, anytime you switch the technology or infrastructure surrounding systems of records. You have to update and assess what that means for the privacy of the data subjects within that data. And then the other part was it took us a while to get the software and code from Galois safe listed. We spent weeks discussing with the IT and the information officers at Ed in order to get that into the Ed systems. And they did not allow us to use a container, for example, such as Docker. So we had to work around that, and that took a bit of time. So thank you for your time, and we look forward to continually advocating for these, pushing on these issues and advocating for these technologies within the Department of Ed.
Thank you so much for sharing your experience implementing PETs with the U.S. Department of Education, including some of the specific data privacy regulations, such as FERPA and privacy impact assessment considerations, doing a demonstration outside of the Department of Education infrastructure, and even how the definition of disclosure for data and the approved parties can be very agency specific and can have important implications for implementing PETs. It was also interesting to note that it can be unclear for statistics agencies to understand which parties are able to view the data when using PETs, so it can be helpful to make sure that's very clear. So I did note a number of questions that were shared in the chat during these talks, and so I see that there are a couple of hands raised, so I'd like to start with those and then also return to the questions that were posted in the chat. So I think, Ronald, you had your hand raised, and then Raphael de Fonville also had a hand raised.
Yeah, I think Raphael was first, Jess.
Okay, so let's start with Raphael.
Sorry, that was a mistake actually. So please, Ronald, you can go.
Okay. Thank you very much. I think I'm very intrigued with the presentation. So thank you very much, Mayank, Matthias, Maria, and Stephanie for these presentations and the introduction into this area of how to be able to share data, right? And then especially for statistical officers, speaking from our community of official statistics, but that's a broader community which also involves what Stephanie was indicating on the education statistics and the more academic field there. So I think one question I have, it's a little bit for all of you. It is on that it seems to me that the introduction of pets should be very attractive for the data protection authorities or those involved in that, because of the fact that there is an audit, right? So Matthias, Maria, you talked about data minimization, right? So it is very specific about what is being asked of the data. You don't have to guess if you share the data, what part of the data is being used and by whom, right? So the pets make that possible to get that audit. I think what I hear, Stephanie, from you was a lot of it is the fact that those who you have to deal with were unfamiliar with what pets actually are, what they can do, and they are sort of holding back of what they don't know. So this socializing of pets, I think, is extremely important. The advocacy on that, and then in particular in the US, I think there is what we've seen now from or heard from those from the Census Bureau who are working with us, that they are working with data officers across various agencies in the US, trying to talk about more about the use of pets. So I think yes, the socializing part of pets is really important. But I think my main question here to all of you, also Mayank, since you described the actors in this and how currently data sharing is being done, because there is some sharing of data at different levels, that the argument that pets actually will improve in almost all cases the process because of clarity and audit possibilities. So my question then is, what would be a counter argument, right? So if you would take this and say, well, we really have to start using pets because it's much better than the current situation that we have, what do you expect as counter arguments? Part of it, I think, was what Stephanie already said, is like, because they don't know, so they don't want to know. But do you see other arguments from the side of legal concerns about why pets could not be used? That's maybe my question. Thanks.
I can take that last part, but I wonder if Stephanie or Matthias or Maria, you want to comment on the first pieces about the national statistics organizations?
I could comment on the first part for a little bit. Thank you. Certainly some of the barriers we faced, or the reasons not to adopt pets that we encountered with some of the ed officials, was the lack of understanding, yes, but also the why fix something if it isn't broken. You know, we've been doing something this way for so long and it works, and we haven't had an issue yet. We don't want to wait for the other side of yet, and we, you know, the urgency, trying to communicate the urgency to people in any agency within, you know, the US, not just the Department of Ed, is really important and often difficult to say, well, you don't want to wait until there's a data breach or a hack, or, you know, you have built trust, but what happens when the people who you trust leave and then they get switched out with someone else? You have to start from the beginning. So I think the why would we bother is a counter argument to our point, and it's the messaging could never be more important on this, for sure.
Just to add to Stephanie's point about, you know, the current tools haven't failed us yet. Another issue with the yet part, in addition to, you know, hacking and data breaches and whatnot, is that attacks only get better over time, right? And this applies, for example, to data re-identification and statistical disclosure attacks. And the United States Census Bureau did an interesting study using the modern methods of data re-identification applied to their older technologies and techniques that they had used in previous Census Bureau microdata releases, and found they were, you know, reasonably effective at re-identifying a substantial fraction of the population. And so even if you're saying, you know, I like my tried and true practices, I like stability, which is great. The attackers are not playing, you know, are not doing the same thing. They are moving full steam ahead, and so that may be a reason to change. But going to the second half of your question, Ronald, about the challenges introduced by pets, I think, you know, a single privacy enhancing technique is just, it's a tool, right? It's a particular piece of software that attempts to solve a particular relatively scoped problem, right? Like, so secure multi-party computation is about, you know, this input privacy problem, right? But if you just use a single tool, like say trying to solve input privacy, you might introduce new challenges down the pipeline, right? So for example, it might make transparency and explainability of results and auditing of results harder. And so there are other privacy enhancing tools. The good news is there are other tools that we have in our pipeline, in our tool belt to address these problems. But my point is just sort of throwing one tool, one hammer at a problem oftentimes introduces new questions, both technologically, like I said about sort of in my example of secure computation, and the questions it introduces about explainability and public verifiability and trust in the data results. And also from a legal perspective, as I said a little bit in my talk about, you know, the existence of pets might make it harder to do something like if a privacy law requires individuals to be able to identify and delete their data. What does that mean in a system where the data is no longer necessarily identifiable by design, right? Like these rules might, they're not inherently in conflict. I mean, with smart thinking and careful, like, I don't want to say like this is a deal breaker, but it introduces, like, each pet you introduces new questions and challenges of its own about its sort of ripple effect throughout other parts of the pipeline. So that's sort of a counter argument. Like, I want to emphasize it's not a deal breaking counter argument that it renders these tools ineffective in a lot of applications. The number one barrier to the use of these pets, like you said, Ronald, in your question, is just lack of awareness of these tools being possible. It requires a mental shift, because it feels intuitive and ingrained in modern society that in order to get a benefit from at a digital data level from a particular service, that you have to provide your data to it. Like, that feels like the intuitive way that you know, we as individuals use services nowadays, like email providers and whatnot. But the fact that this is not quite true, and that you can actually decouple sort of getting a benefit from a particular entity from the fact of having to disclose or provide data to it is a very neat but kind of mind-bending thing. But as Stephanie was saying, the nice thing is, once you talk with folks, it's actually not too difficult to explain how these technologies work. You know, getting into the details for a specific use case and having a detailed conversation between technologists and lawyers, as Maria was saying, is complicated, but important. But at least just sort of introducing people to this idea, it's possible to do.
I think using pets, that's a method I can also explain to my family, for example, that it's much more discreet to only extract that information that you need for your research. So you have less risk to do the function creep when it's all on one place. So I think that are so much more attractive to use pets, that it should be always above getting the data in your organization. So that's why I think the techniques should be less complicated if we use all the same techniques. So if that could be unified from the primary source, that should be better. But we're not that far. But I think that should be where we should end within several years.
And I think also standardization should play important role in this, because like the way how this started was, there are very, very diverse techniques. They are also very diverse providers of technologies. Some of them starting as a kind of startup. Some of them are big players. So the field is not yet, how to say, probably mature yet and standardized yet. And they are emerging standards. So there is the community of homomorphic encryption, for example, working on industry standard. So to make sure that these requirements are more universal, are better understood, and then can be also more easily audited. And I think that will really contribute when we have more of this standardization in place. So that's one perspective. The second perspective is the privacy regulators. So what we can also see, I mean, even in European Union, where we have GDPR as a kind of privacy regulation, is that there is a difference of interpretation by different countries' regulators. Some are more conservative, some are less conservative, and also here we see that we need more time. That also regulators kind of how to say more aligned with each other on what is acceptable level of kind of techniques for some particular purpose. But to finish. Our use case was kind of coming from different perspective than what Stephanie explained. So in our use case, we didn't have the classic way of doing it. So we haven't been doing this before. So there was a new use case, completely different. And I think in our case, if we wouldn't agree to go with pets, that project wouldn't be possible. It wasn't, the pets were not a silver bullet, so we didn't how to say we couldn't
but also the purpose of this research so for the insurance company, for CBS, and for the hospital, everyone is convinced that the purpose was ethical, right?
Yeah.
The GDPR and also all privacy laws they are based on human rights, so that is very universal.
Yeah.
So if you want to cooperate international, then you can say that privacy is a human right.
Mm-hmm.
And from that point of view, all the legal aspects and also the ethical aspects, you can explain it while you use the human rights issue.
Yeah, which I think brings us nicely also into the role of UN in this, because I think it's more than just how to say educating people and trying to assemble use cases, but also, yeah, in a way providing the direction that this is the way to go, also from the ethical and human rights perspective.
Thank you so much for that. There are two questions that relate to what we're talking about right now, and then a few from earlier in the talks that I'd like to return to. But it was noted in the chat that is part of the problem trying to frame this as a new way to do data sharing, where maybe it would be better framed as an alternative to data sharing. So any of our speakers that would like to comment on that, please.
Yes, I agree with this. I like to call pets, generally speaking, when I describe it, I just say we're trying to do data science without data sharing. I think avoiding the data sharing point is important.
I think data sharing is just like pet, just not the purpose, but the middle. So I agree with you, Mayank.
Thank you for that. And then the other question was, do you feel like it would make a difference if the technology underpinning pets were widely documented, implemented, the federal agency implementing it were more sort of perceived as in the laggard phase of the innovation curve? So at present, pets might be seen as something for early adopters at the moment. So better understanding that that this is something for which there already is some basis. Do you think that that might make it easier to better manage expectations?
Yes, for sure. I appreciate this question. So I'm thinking of not just the NCES pilot that Amy and I did, but we also conducted a landscape analysis of pets in education in the US through a Gates Foundation grant. And so we spoke to about 40 education stakeholders at the federal level, state level, local level, technologists, et cetera, researchers. And we did hear a lot of, some of that refrain, are pets ready for prime time? How do I implement this? We used for our NCES pilot, we partnered with a software provider, and that involved a lot of legwork that agencies don't have time for, they don't have the staff for, they don't have the training, they don't have the capacity, et cetera. What we have said to that is, yes, there is space and certainly need for more research and development and investment in research and development to work out certain remaining technical questions about a lot of these technologies that Mayank and others can probably speak to more than I can, but they have been used a lot more than we've realized. And we talked to some, for example, ed tech providers who didn't even realize they were using what could be considered a privacy enhancing technology, even if it's a secure enclave or trusted execution environment. It's sometimes just a difference in wording. So I think it definitely is ready, and there's a lot of open source software out there that makes it easy for groups to adopt it if they want. So it depends where you want to go with it. If you're trying to do something very complicated with insecure multi-party, like fuzzy linkages, that's still, I know in the international community, that's still being investigated. But if you want to do a direct match like we did, just a private set intersection of two data sets and then compute a simple weighted average using secure multi-party, you could definitely do that today.
Yeah, I think that I agree with everything Stephanie said, and I think that national statistical organizations are in some sense laggards in using this technology, that it is being used in other contexts, but they're also laggards for a sensible reason, because they have to consider a lot of these legal and regulatory considerations that some other applications that were more early adopters did not. So speaking just for myself, not a comment on behalf of the entire legal task team, one of the primary reasons I was drawn to this set of questions and participating on this task team is because when I was looking around sort of 4 or 5 years ago at the use of these technologies like secure computation and other things, like a lot of the applications that have happened to date have been in scenarios where data is something that people intuitively think of as sensitive, but is not technically covered under any data privacy law, at least in the United States where I live. So an example is work we've done in the city of Boston to compute the gender wage gap using salary data. Salary data is something most people view as sensitive, but there's no privacy protection law that restricts it here. With caveats, asterisks, whatever. And so my worry was that the scenarios that most need these pets, because they're the most important private data that we've chosen as a society to bequeath with these data privacy protection laws, are also the laggards in adopting it, precisely because of the challenge of mapping the technological guarantees onto the legal requirements, which is like a funny but unfortunate paradox. And so that's part of the goal of my own contribution towards this legal task team.
Another question is that legal advisors don't often fully understand the technology being used and have to make educated guesses, which mean there are gaps in compliance. Would you see a data protection professional as needing to be embedded in a project, or are they less relevant to legal advisors? Do you mean them as one and the same, maybe? And I think this may have been in relation specifically to Statistics Netherlands.
Often the CPO is also a lawyer, so not always, but he or she has another role. So I think it's important that both are involved with the project, because a lawyer is not only for the privacy, but also for to make up the agreements, etc. And the CPO, the Chief Privacy Officer, just controls looks for the other privacy issues, not only the legal issues. So I think both are very important to this case.
Also, perhaps specific to synthetic data, which is just one in the family of pets, but in a scenario where we wish to publish synthetic data, there's some understanding that the legislation would focus on the privacy of the output. However, privacy methods like differential privacy apply to the algorithm itself, which is used. So can legality of the output be inferred or carried forward from the machinery, or does that need to be established independently?
Actually, if the legal advisor can be convinced that their data is not anonymized, we still have the privacy problem. So in that, I don't know exactly all technical issues also with synthetic data, but if synthetic data still is personal data, then legally we deal with the GDPR in our instance.
Just to add quickly, this is a good question. I think maybe I'll abstract the question to saying, you know, how do we think, you know, the technologies are thinking probabilistically rather than deterministically, right? They're thinking at a distributional level, and laws often don't, or at least aren't written in such a way directly, which is true. But this is also not a new issue, right? Technically speaking, this also applied to encryption, which is technology that has a lot of regulations and guidelines from regulatory agencies about rules that apply to it. So differential privacy is a newer technique, of course, and hasn't been as well, studied, and aren't as many official guidelines from regulatory agencies. But I think this question of thinking probabilistically and adapting that is not a new question. So I think sort of everything we've done over the past 40 years to try to think about how to standardize the extent to which encryption does and does not satisfy privacy laws, which is already a nuanced take. There's never, a law that just says encryption solves all your problems definitively, full stop. It almost never does this. I've never seen one, at least. So these kinds of questions have existed before, is all I'm saying.
Thank you for sharing that perspective. One of the attendees noted that there's a huge focus on healthcare use cases for pets, which they think is excellent throughout the world, yet to the detriment perhaps of other sectors of local and central government services around the globe. So how would you propose development of engagement outside of healthcare?
Yeah, in one respect, the health use cases are, they have some sort of priority in a way in this, recent developments. And the other thing is that they often are seen as, the most sensitive area. So one thing is that this actually helps, because if you have, addressed the use case involving medical data, then the rest can be perhaps easier, or you can apply learnings on other use cases and solve certain use cases easier. That's kind of a positive perspective. But on the other side, yes, I think the pets are applicable to many other areas, not only medical data, or not even only the privacy
if you can use
regulation, but also some other confidentiality based use cases, and we should use it.
Yeah, because if you can use it for health data, then less sensitive data is also allowed for pets.
I'll just comment here as building upon what Maria and Mattia said, that this is one place where maybe our friends in the European Union have an advantage over us in the United States in that last sentence that Maria just said. Whereas in the US and some other countries in the world, there are more sector specific laws. And the point is, even if we as a society believe that healthcare is one of the more sensitive pieces of data, which we do, the translation to other privacy laws is not nearly as direct, which is one of the reasons why we're interested in sort of systematizing or abstracting features of laws to try to do that mapping into a new environment with a new set of privacy regulations to see how that mapping works.
If I can add to that, there definitely is discrepancies across privacy laws. And sometimes in my experience trying to push this in the education field, it is great to be able to hold up examples of other fields, like look what has been done, Mayank, the example of the Boston women's workforce and using financial data and using health data, and in our defense agencies, for example, they're using a lot of the way ahead of the market in terms of using privacy preserving technologies. But something interesting, HIPAA, the fundamental health data privacy law in the United States, does not consider encrypted data as a breach or a disclosure. Whereas under FERPA, from the beginning conversations we've had with those lawyers, they are, leaning towards considering, yes, the encrypted data, that's still considered disclosure. And so it's interesting, health data is arguably even more sensitive than education data. So I think some common understanding, there's confusion around different privacy laws too, not just between health, education, other agencies and other topics, but within education alone. How do FERPA and the Privacy Act and the e-government Act, how do all of them interact? So that is something that certainly confuses potential users.
Great, so many good questions and also some really good conversation happening in the chat, particularly around synthetic data, which I hope will move over to the UN Pet Lab community Slack channel, which I'll post again in just a moment. But at this point in our meeting, we'd like to invite a few of those attending to introduce themselves, their organization, and the use case that interests them related to the UN Pet Lab. So we definitely, in this last home stretch of our meeting, we won't have time for everyone to introduce themselves, but we do set aside time at each open house for this. And then, of course, there's also our Slack community where you can do that as well. So if you would like to introduce yourself, then please go ahead and raise your hand or put some note in the chat, and we'll have maybe 1 to 3 introductions, time depending, so that we can conclude the open house on time.
Right. Yes. If I come in and how you say this, with the taking a dangerous position of putting people on the spot. First of all, let me take this opportunity to again thank you all for this very engaging and interesting discussion on a topic, I think, which is really on the forefront of how we can improve data sharing, especially also for our statistical community. So I will pick, we don't have that much time, and I would like from 2 different areas to pick some people, maybe if they want to introduce themselves or indicate their interest. I also see Alicia here, but if I could pick out Ehsan Gashim, he's from the Canadian Revenue Authority. And given the fact that we've been talking about various kind of data sources, I mean, Revenue Authority, I think, is one of the ones we really also like to see how that works with the statistical community. So I don't know, Ehsan, if you want to say something about your interest and maybe your interactions already with the Stats Canada on data sharing. So that would be a request. If I think we should give you the possibilities to speak if you want to. That's to my colleagues to make that possible. Ehsan Gashim. Then
yes.
Yes. So and then yeah, please go ahead, Hisham.
Yeah, thank you so much for introducing that, and very interesting presentation. Yeah, here the CRA, Canada Revenue Agency, we are dealing with the taxpayer information, so which is very sensitive data, and in releasing public data, including taxpayer, is a very sensitive topic for us. So we are using multiple methods, including differentially private methods right now, and we are evaluating the privacy output of those methods. So I guess the topic of the privacy enhanced technology is very important for our agency as a whole, in case we need to adopt those methods in releasing micro level public data that include taxpayer information. So.
Thank you very much, Hisham. Thank you for taking for being put on the spot and for introducing yourself. Thank you very much. So let me go to Alicia, who has her hand up. Alicia, maybe you can introduce where you're coming from.
Hi, good morning. Still here in Trinidad and Tobago in the Caribbean. Yeah, so first of all, let me apologize for not being able to use my camera because my bandwidth is a little low. Of course, these are some of the other issues we deal with on the internet end of things. But I'm particularly interested. I'm first of all Alicia Shepherd from the University of the West Indies, a lecturer in research methods for project managers in particular. So the presentation today in the education realm is very, very important for me and, of course, our entity at the University of the West Indies. I'm listening. I'm very new to a lot of the PET methodologies that you've spoken of today, and we are really looking to employ some of them. For instance, I'm also part of the Project Management Institute, and we have a volunteer project that we're looking to introduce project management throughout the country to all primary and secondary school students. And this issue of data and education data is so important because right now we're actually dealing with that issue because we're collecting so much data from the schools, and where to store it, how to share it is an issue that we are really grappling with at this point in time. We at the PMI SEC, which is a Southern Caribbean chapter, we are looking to employ some of these methodologies when it comes to privacy of data and encryption and that sort of thing, because I'm the monitor for the project. So of course I'm responsible for ensuring that the data is kept in its confidentiality state, you know. So I'm really, really interested in what Stephanie in particular has mentioned so far this morning. So I'm really looking further into those technologies that you've spoken of. So thank you both to Matt Jazz and I think it's, yeah, Matt Jazz and Stephanie. Yeah, both presentations that I've heard so far. So thank you so much, guys.
Thank you, Alicia. And I think we'll definitely should get you in touch directly with Stephanie and the team there, so you can compare notes and see how that could work forward. So I'll make a point to make sure that we exchange the information between the two of you.
Wonderful.
And then you can take it from there.
Thanks.
Very good. Yeah, and also I noticed, Stephanie, you're working with Dave Archer, and Dave is also part of the PET lab. So there is some further connection also there going forward. Okay, we're very close to the end. And before giving back to Jess, maybe a 1-minute introduction, if you can, David Blaskowski. So we've introduced quite a few private sector in previous open houses. David, I saw you in the chat, and I saw your from the private sector. If you can give you 60 seconds maybe to introduce, and then we'll give back to Jess. If Clarence, if you can give David the possibility to speak.
I don't see him in the meeting anymore.
Oh, he's not there anymore. Okay, then it goes straight back to Jess for the last word.
Okay, so I guess we'll just conclude today with our appreciation to all of our speakers and for all of you who joined us today for the open house. And again, please join the UN Pet Lab Slack channel, which I posted in the chat. Feel free to send me a message if you had some trouble connecting to that, and we'll make sure that you added. We look forward to seeing you again at the next monthly open house. The open house events are posted on the UN Big Data webpage, where you can also view the past events. And so thank you for joining, and we'll see you in the Slack community until our next meeting.
Thank you all. Thank you.
Thanks, Tom.
Thank you.
Everyone.
Thank you.
Thanks,
Bye.
everyone.